I have some new, extremely important information that you're going to like about whether or not the Supreme Court is going to grant cert in the Snope case dealing with Maryland's AR-15 ban, the semi-automatic rifle ban. I think it's really good news. I've connected up some extra dots here. You're not going to want to miss this one. Let's talk about it. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so you know how I explained to you that I sometimes have to talk about other aspects of the law, other aspects of Supreme Court practice, bring it all together as kind of like a spider web where you got to understand you pull one part of the web, the entire web moves. You got to understand all this. Well, I've talked to you a lot about Supreme Court practice, Supreme Court tendencies, Supreme Court history, because by teaching you these things, it makes you the smartest person in the room with respect to all sorts of things about the law, but in particular, the Second Amendment, because there's a lot of things that weigh on our Second Amendment rights. One of that is Supreme Court trends and practices. Now, with that said, you know that last week I discussed, statistically speaking, that we are now in a world where the Snope case and the Ocean State Tactical case have been relisted over 13 times. And statistically speaking, the odds of some sort of positive response from the U.S. Supreme Court in the Snope case in particular, and maybe even Ocean State Tactical, I think that's a harder case, for now at least, I think the odds are dramatically now rising because we're now in a very big number of relist. And just to jog your memory, as you know, the U.S. Supreme Court is not obligated as a general matter to hear any case. And when they do hear a case, it arises in the context of somebody seeking a petition for cert. They file a petition for cert saying, please, Supreme Court, hear my case on the merits, and decided. And the Supreme Court gets thousands and thousands of these petitions, these requests from people to hear their particular case about all aspects of American law, which is a very big topic. And the Supreme Court now grants cert in about 60 to 70 cases a year. So it's very difficult to get your case granted cert by the U.S. Supreme Court. And as you know, there are two cases that, in my opinion, it's very important that the U.S. Supreme Court grant cert in. In particular, that's the Snope versus Brown case out of Maryland, which deals with a Second Amendment challenge to the AR-15 ban, the semi-automatic rifle ban in Maryland. And there's a related case called Ocean State Tactical arising out of Rhode Island dealing with quote-unquote large capacity magazines, which are really just standard capacity magazines. But I don't think the Ocean State Tactical case is going to be granted cert anytime soon because it's on a preliminary injunction basis. It's an interlocutory appeal. And I think the magazine question is just more complicated from the perspective of the U.S. Supreme Court. And I think the AR-15 semi-automatic rifle case is right down the middle. You just apply Heller and the Second Amendment wins. Okay, so with that background and context, what have I uncovered here that I think is extremely good news? And that is this. There is a case out there that has been relisted somewhere in the order of magnitude of like 14 or 15 times, like Snope and Ocean State Tactical. This case is a case called Apache Stronghold. Apache Stronghold versus United States. And you're like, oh my God, Mark, what are we talking about, Mark? What do we care about this stuff? Here's the why you care. Apache Stronghold versus United States there was a petition for cert filed in this case arising out of the United States Court of Appeals for the Ninth Circuit in the late fall of 2024. Okay, it has been relisted for something like 14 or 15 conferences. It is still pending. Now, why do you care? And why is this good news? It's quite simple. Apache Stronghold presents a constitutional question involving the religious clauses of the First Amendment. The U.S. Constitution, Bill of Rights, has 10 amendments. The Second Amendment, of course, is the right to keep and bear arms. We know all about that. The First Amendment speaks to various other rights, including the right to a free press, the right to free speech, and the right to the freedom of one's religion, the right to exercise your own religion, and kind of relatedly, it bans the establishment of a religion so that the United States government cannot become like the national religion is officially the government's religion of Catholicism or whatever it is, okay? Can't do that in the United States because of the Establishment Clause, which is in the First Amendment. Now, the reason why this matters is Apache Stronghold deals with those religious clauses as applied to some property right disputes out there in Arizona. You don't need to know the details. You just need to know that this is a case that has been relisted 15 times since the late part of 2024. It deals with the First Amendment's religious clauses, and the attorney on this case is Aaron Murphy of the law firm Paul Clement and Aaron Murphy, or Clement and Murphy. Very strong Second Amendment lawyers, among other things, prominent big-time Supreme Court litigators, and so on and so on. By the way, the law firm of Clement and Murphy is not just the lawyers on Apache Stronghold dealing with the First Amendment's religious clauses that is still waiting to hear if they're going to be granted cert. They're also the law firm that represents Ocean State Tactical on their cert petition, and presumably, if they seek cert in the Duncan case out of the Ninth Circuit, Aaron Murphy argued that case. I would assume that if anyone seeks cert in the Duncan case, which is a final judgment case involving the California magazine ban, it would likely be, among others, Aaron Murphy's law firm seeking cert on that case. Now, why does all this connect up and show a good bit of news? And here's why. Remember how I explained to you there's only 60 to 70 cases a term in the U.S. Supreme Court that they hear on the merits? That's it, 60 to 70 a year. It covers all aspects of American law: tax law, ERISA law, First Amendment, Second Amendment, APA issues, ATF issues, EPA issues, and so on and so on and so on. This term, listen carefully, folks, this term, the Supreme Court, in the term of 2024 through June of 2025, has three religious clause cases involving the First Amendment. They have a case out of Wisconsin as to whether or not a kind of a charity qualifies for a religious exception or an exemption under using the First Amendment to get them out of some state-based taxes. That's the case called Catholic Charities Bureau versus Wisconsin Labor. There is the case called Oklahoma Statewide Charter against Drummond. That is the second religious clause-based case. That involves questions about charter schools and whether or not a Catholic school, a purely private Catholic school, is entitled under Oklahoma law to have a charter, and the denial of that. Would that violate the religious exercise clause of the First Amendment, or granting a private school, Catholic school, a charter under Oklahoma law, would doing so create an establishment of religion in violation of the First Amendment? And then, of course, you have the Mahmood case versus Taylor, which is out of Montgomery County, Maryland. Being a Prince George's County guy myself, one of those athletes you probably read about back in the day. I'm not a Montgomery County fan, being a PG County guy. But with that said, this case arises out of Montgomery County. This is a very interesting case dealing with parental rights, where you had religious parents that did not want their young children in a public school to be exposed to LGBTQXYZ propaganda and materials. They wanted their young kids to be exempted from that. The public school says, no, you have to expose them to that LGBTQT, whatever that is, stuff. And they said that if you force the kids to be exposed to this, that violates their First Amendment rights under the religious clauses. Now, the reason why this all comes together, remember, we put this together, big picture is this. The Supreme Court has 3 religious liberty cases this term out of their 60 to 70 cases. They are not going to take another one. They are pushing it off, almost certainly, in my opinion, to next term. It's kind of a scheduling thing. Therefore, the Apache Stronghold First Amendment case handled by Aaron Murphy's firm, Clement and Murphy, has been relisted 15 times, I suspect because the Supreme Court did not want to hear a 4th First Amendment case this term. And because the Supreme Court has already has 3 religious liberty cases, they don't want to take a 4th, which means it's telling me they've relisted Apache Stronghold 14, 15 times because they intend to grant cert in it and shove it into the 2025-2026 term. Now, with that said, let's now draw that analogy to what's going on with the Snope case in their 13 relists. Remember, this term we've already had 2 Second Amendment related cases because the Supreme Court views their Second Amendment cases and gun cases and ATF cases as kind of one and the same. And this term, the Supreme Court is going to rule for the gun industry against Mexico in that Mexico versus Smith & Wesson case arising out of the U.S. Court of Appeals for the First Circuit in Boston. That's one of those Second Amendment related cases for this particular term. The second one, of course, is the Vanderstock case, which we sort of lost, sort of meaningless because it's sort of blessed a Joe Biden regulation that's going to go bye-bye anyway. But technically speaking, the Vanderstock case was also a Second Amendment related case, even though it's not specific to the Second Amendment. So what appears to be happening, this is again still speculation, but I think it's starting to become good speculation. What appears to be happening is they've relisted the Apache Stronghold case so many times in the same way they've relisted the Snope case so many times in basically the same time period, because just like they don't want to take 4 religious freedom cases in this term because they only have 60 to 70 cases total, I suspect they don't want to take 3 Second Amendment related cases this term because they've already resolved 2 of them, or are going to resolve 2 of them. So I think there's a very good chance that the Supreme Court has been relisting Apache Stronghold in the First Amendment religious clause context to push it off as a matter of scheduling into next term. And I suspect they may very well now be doing that with Snope and maybe even Ocean State Tactical, but I really think that Ocean State Tactical will not be granted cert. I suspect what will happen is that they will grant cert to Snope, which is the AR-15 semi-automatic rifle case, because I think that's really straightforward for them. They will decide that case. They will take the Ocean State Tactical case, which is being handled by the Clement and Murphy firm. They will stick that on a shelf. They will then decide Snope. And then what will happen is Aaron Murphy's firm will seek cert in the Duncan case out of the Ninth Circuit. And at that point, what will happen is the Supreme Court will decide the Snope case, reestablish the in-common use test, have some discussions about what constitutes an arm as a matter of the text of the Second Amendment. The right of the people to keep arms shall not be infringed. They will clarify some of those standards, I suspect. And then they will GVR both Ocean State Tactical, which is on a preliminary injunction status, and Duncan back to the lower courts to rule consistent with what the Supreme Court decides in the Snope case. And again, the fact that they have relisted Snope and Apache Stronghold basically these 13, 14, 15 times, and they already have multiple Second Amendment cases this term, multiple First Amendment cases term dealing with religious liberties, it's telling me that these relisting things may very well be part of really a scheduling plan by the U.S. Supreme Court. Again, I don't know exactly what's going on. There may be some negotiations going on. I am sure if you almost force me to bet, I am sure we have at least 3 votes guaranteed to grant cert. Justice Alito, Justice Thomas, and Justice Gorsuch is my guess. And I think we're in very good shape with Justice Kavanaugh. And there's no doubt in my mind, if they grant cert in Snope, we win that case. The issue is getting the Supreme Court to step up and grant cert in an AR-15 semi-automatic rifle case and have them take one of their 70 precious slots and dedicate it to this issue. Obviously, I know the Supreme Court really likes their religious cases. They like their First Amendment cases more than Second Amendment cases. I think that's apparent. That's not how I would prioritize things if I were on the Supreme Court, but I'm not. So I have to talk to you about what the reality is and not what I wish the reality were to be. So anyway, I think this is all good news. And I think if you look at the trends in the First Amendment religious clauses context, and you look carefully at what's going on with this Apache Stronghold relisting situation versus what's already on the docket, I think this really does speak to these relisting these cases is really a scheduling issue. And I got my fingers crossed that we're going to find out very soon that these cases will be granted cert and argued next year. But again, only time will tell. The history of the future is yet to be written, but I'm cautiously optimistic we're going to be okay in the end, but we'll find out soon enough. So there you have it, folks. I hope you liked today's episode. Make sure you follow me on X at @4boxdiner. Don't forget to subscribe both to YouTube and Rumble, and I look forward to talking to you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.